Good afternoon, everyone, and thank you for joining us for today's New York State Paid Family Leave webinar for public employers. I'm Mike Gifford, and I'm here with Jen Donovan from the Outreach Unit of the Workers' Compensation Board. Today, we're going to provide you with a brief guide to New York State's paid family leave. We will also point you to some helpful resources at the end. We ask you to please keep your phone lines muted, as we'll be using the chat feature to receive your questions today. Please enter your questions throughout the presentation in the chat box located on the right side of your screen. Use the drop-down to send your questions to the host or presenter. You can also hover over the WebEx tab at the top of your screen and click on Chat. Courtney Valley from the Board's Office of General Counsel is also here to help us answer any of your questions. We will answer as many of your questions as we can, but if you have questions that we don't get to today or think of something after the session ends, we will be providing you with the resources at the end of the presentation. At this time, I'll pass it over to Jen.
Thanks, Mike. As Mike mentioned, today we'll be sharing important information with you regarding New York paid family leave. As public employers, it's important that you are well informed regarding this life-changing benefit that you have the option to secure for your employees. As you may be aware, New York paid family leave is an insurance benefit that public employers can easily opt in to provide for your employees at no direct cost to you. But you may be wondering, why the need for paid family leave in the first place? For too long, employees have struggled to maintain their jobs when they needed to care for a loved one during a specific time of need, whether that was welcoming a new baby, caring for a family member with a serious health condition, or dealing with family pressures when a spouse, domestic partner, child, or parent is deployed abroad on active military service. These pressures can affect job performance and spill over into the workplace. Research shows that paid leave increases the likelihood that employees will return to work, which increases retention and ultimately lowers costs for employers. There are a number of factors that a public employer should consider when deciding to opt into paid family leave. This presentation will begin by answering the question, what is New York paid family leave? And then provide a tailored walkthrough of some of the key considerations specific to public employers, including what you as a public employer need to know about opting in and how to get coverage for union employees, an overview of the responsibilities of covered employers, how paid family leave interacts with other benefits, and finally, the many resources that are available to help you navigate the benefit with your employees. Of course, we'll also leave plenty of time at the end to take your questions. So let's get started with an overview of what New York paid family leave is. Paid family leave is insurance fully funded through employee contributions. Paid family leave provides job-protected, paid time off from work for employees to bond with a newly born, adopted, or fostered child, care for a family member with a serious health condition, or assist loved ones when a spouse, domestic partner, child, or parent is deployed abroad on active military service. Paid family leave provides time off and wage replacement benefits that are phasing in over a 4-year period that began in 2018. This year, eligible employees can take up to 10 weeks of leave at 55% of their average weekly wage, up to a statewide cap. The program will be fully phased in by 2021, at which time eligible employees will be able to take up to 12 weeks of time off at 67% of their average weekly wage, again up to a statewide cap. Let's take a closer look at each of the 3 uses or qualifying events for paid family leave. We'll start with bonding with a child. Paid family leave provides both parents time to bond with a new child within the first 12 months of the birth, adoption, or foster placement of the child. This includes children born, adopted, or fostered in 2018, as long as the leave is taken and completed within the first 12 months of the birth, adoption, or foster placement. Parents who work for different employers can take paid family leave at the same time to bond with the same child. Parents who work for the same employer can take it at the same time unless their employer prohibits it. In that case, they can take leave separately over the first 12 months following the child's birth, adoption, or foster placement. It's important to note that expectant mothers cannot take paid family leave for their own pregnancy. They can take it after the baby is born because paid family leave is used to care for family members. A parent may be able to take paid family leave before the actual adoption or placement of a child if an absence from work is required for the adoption or placement to proceed. Paid family leave is also available for employees to care for a family member with a serious health condition, which we'll define in a moment. Employees can take time off to care for their sick spouse, domestic partner, child, stepchild, parent, parent-in-law, step-parent, grandparent, and grandchild. Siblings are not covered. To clarify, domestic partner is defined broadly under the paid family leave law. It includes people who are not related by blood in a manner that would bar marriage in New York State and are dependent on one another for support. For example, an employee may be able to prove that they are in a domestic partnership by showing that they own property together or have children in common. A legal relationship is not necessary. It doesn't matter if these family members live outside of New York State or even outside of the country. Employees can take paid family leave to care for their family member as long as they are within close and continuing proximity. In other words, present at the same location as the family member they're caring for during the majority of the paid family leave period. This includes travel for the purpose of securing medication or to arrange care for their family member and other activities related to providing care. In order to take this type of leave, the employee's family member must have a serious health condition. A serious health condition is defined as an illness, injury, or condition that requires either inpatient care in a hospital, hospice, or residential health facility, or continuing treatment or supervision by a healthcare provider. Here are some examples of conditions that may qualify as a serious health condition. Perhaps an employee needs time off to provide emotional support for their mom when she undergoes chemotherapy. Or an employee's dad had surgery and needs help recuperating at home. Or an employee's child is undergoing treatment for addiction and cannot attend school for a period of time. These are situations that may qualify for paid family leave if certified by the patient's healthcare providers. For example, a physician, nurse practitioner, or clinical social worker. Non-serious medical conditions such as the common cold or flu, routine dental work, or cosmetic treatments are generally not included. However, if medical complications arise and a family member then meets the guidelines for a serious health condition, it may be eligible. The third type of leave is for assisting during a military deployment. Paid family leave benefits are available when employees have a spouse, domestic partner, child, or parent on active service abroad or who has been notified of an impending call or order of active service abroad and family assistance is needed. Eligibility for paid family leave for an active service deployment is the same as the military provisions of the Federal Family and Medical Leave Act, or FMLA. There are a number of instances where paid family leave will help, shown here. In addition to paid time off, New York's paid family leave also has strong employee protections. Employees are guaranteed to return to the same or a comparable job after taking paid family leave. A comparable job is defined as a position with comparable employment benefits, pay, and other terms and conditions of employment. Employees are guaranteed continuation of health insurance on the same terms as if they had continued to work while out on paid family leave. If employees contribute to the cost of their health insurance, they must continue paying their portion of the premium while on leave. Employees are also guaranteed protection from discrimination and retaliation. Requesting or taking paid family leave cannot be held against them. If for some reason an employee's paid family leave request is denied, or they have another claim-related dispute, such as amount of benefits or timeliness of a carrier's decision, they may request to have the denial reviewed by a neutral arbitrator. The insurance carrier or employer of self-insured will notify the employee of the reason for denial and provide them with information about requesting arbitration. Arbitration for paid family leave is handled by NAM, or the National Arbitration and Mediation. More information on arbitration is available at nyspfla.com. As mentioned earlier, employers may not discriminate against an employee for requesting or taking paid family leave, and an employee is guaranteed job protection with the same or comparable job upon return from paid family leave. If the employer does not return an employee to the same or comparable job, terminates the employee, reduces the employee's pay and/or benefits, or disciplines the employee in any way as a result of the employee requesting or taking paid family leave, the employee can file a discrimination claim with the Workers' Compensation Board. An administrative law judge may order an employer to reinstate an employee, pay any lost wages, pay attorney's fees, and pay up to $500 in penalties. The process and forms are available at paidfamilyleave.ny.gov, or employees can call the Paid Family Leave Helpline for assistance at 844-337-6303. Paid family leave is fully funded through employee contributions. Each year, the Department of Financial Services sets the employee contribution rate to match the cost of coverage. For 2019, the employee contribution is 0.153% of an employee's gross wages each pay period. The maximum annual contribution is $107.97. Employees earning less than the current statewide average weekly wage of $1,357.11 will contribute less than the annual cap of $107.97, consistent with their actual wages. To estimate employee deductions, you can use the payroll deduction calculator at paidfamilyleave.ny.gov/Paid Family Leave Calculator 2019. Paid family leave coverage is not optional for eligible employees. Employees can waive coverage if they regularly work 20 or more hours per week, but won't be in employment 26 consecutive weeks, or if they regularly work fewer than 20 hours per week and won't work 175 days in a 52-week period. Seasonal workers are a good example of this, as they may work full-time, but for only 3 months out of the year. If an employee meets the criteria for waiving coverage, the employer must provide them with a waiver form, which is also available on the Paid Family Leave website. If an employee waives coverage, they will not make contributions and will not be eligible for paid family leave benefits. Employers should keep a copy of an employee's waiver on file. If an employee's schedule changes, such that they no longer qualify for a waiver, their waiver will be automatically revoked within 8 weeks of the schedule change. An employee can also voluntarily revoke a waiver at any time. If an employee's waiver is revoked, their employer will begin taking paid family leave contributions and collect any retroactive amounts due. So now that we've covered the types of leave, the benefits, and the costs, let's discuss who is eligible to take paid family leave. Most private employers with 1 or more employees are required to have paid family leave insurance for their employees. As we'll discuss in more detail shortly, public employers may opt into the program. Employees of public employers who are represented by a union may be covered if paid family leave is collectively bargained. For covered employees, eligibility for taking paid family leave depends on meeting specific requirements for the amount of time employees have worked for their employer. Full-time employees who regularly work 20 or more hours per week are eligible for paid family leave after 26 consecutive weeks of employment with the same employer. Part-time employees who work a regular schedule of fewer than 20 hours per week are eligible after working 175 days, which do not need to be consecutive. Citizenship or immigration status is not a factor in employee eligibility. There are a few frequently asked questions about paid family leave and other leave benefits that may be helpful for you to know. There are several similarities between New York's paid family leave and the Federal Family and Medical Leave Act. Both provide leave for bonding with a child, caring for a family member with a serious health condition, and assisting when a family member is deployed abroad on active military service. Employees are also guaranteed that they'll return to the same or similar position, and their health insurance will continue on the same terms as if the employee had continued to work. If employees contribute to the cost of their health insurance, they must continue to pay their portion of the premium cost while on leave. But there are a number of key differences. Paid family leave is paid, FMLA is not paid. Almost all private employers will carry paid family leave insurance. FMLA does not include insurance, and it has a 50-employee threshold for eligibility. The length of time an employee must work is different. In paid family leave, an employee who regularly works 20 or more hours a week must be in employment for 26 consecutive weeks for that employer, and an employee who regularly works fewer than 20 hours per week must work 175 days for the same employer, which do not need to be consecutive. For FMLA, employees must have worked for a full year and 1,250 hours in the last 52 weeks to qualify. The biggest distinction may be that under New York's paid family leave, an employee is taking leave to care for someone else, not for their own health condition. FMLA allows employees leave for their own health condition. Paid family leave is only taken in full-day increments. FMLA may be taken hourly. Also, under paid family leave, employees do not need to use other paid time off first. So what about paid family leave and other leave types? Employees cannot collect short-term disability and paid family leave benefits for the same period of time. A birth mother can, for example, take short-term disability if she qualifies and then take paid family leave. It's important to note that the total amount of time taken for disability and paid family leave cannot exceed 26 weeks in any 52-week period. Employees cannot collect paid family leave benefits while collecting workers' compensation benefits for a total disability. Employees who are on a reduced earning schedule may still be eligible for benefits. Paid family leave was designed to be easy for employers to implement. I'll now walk you through the 3 key responsibilities for employers. The 3 main responsibilities for employers are to secure paid family leave coverage for their employees and paying for the premium with funds collected from employee payroll deductions, provide information about paid family leave to their employees, and provide wage information to the carrier when an employee requests paid family leave. Public employers may decide to voluntarily opt into paid family leave at any time, although there may be notice requirements. A public employer is defined by law as any political subdivision of the state, a public authority, or any government agency or instrumentality of the state. It is important to note that once a public employer opts into paid family leave, coverage must be maintained for at least 1 year. The process for a public employer to opt into paid family leave is easy. There are a few considerations which we'll go through in a bit more detail. First, which employees will you provide coverage for, and when will your coverage begin? How will paid family leave interact with your existing benefits? And how will you obtain coverage? So let's start with which employees you will provide coverage for. You can decide to provide paid family leave coverage for non-represented employees at any time, for example, MC employees. You must give employees and the Workers' Compensation Board 90 days notice before taking any payroll deductions. Represented or union employees can only be covered for paid family leave if the benefit is negotiated through collective bargaining. A labor union may negotiate with a public employer for paid family leave benefits at least as favorable as those mandated by statute. Public employers should also consider the following. Do you have existing leave benefits? And if so, how will paid family leave and those benefits interact? How will paid family leave interact with accruals and FMLA, if applicable? And will you provide service or retirement credit while an employee is on paid family leave? These are decisions you as the employer can make when implementing paid family leave. You can obtain paid family leave insurance coverage by including paid family leave benefits through a rider on an existing disability benefits policy, purchasing a standalone paid family leave insurance policy, or self-insuring for paid family leave. A list of insurers offering paid family leave policies is available on the Department of Financial Services website. Please note that obtaining coverage for represented employees is conditional on the terms of the collective bargaining agreement. Once you have obtained coverage, you must notify the Workers' Compensation Board of your decision to opt into paid family leave. If you currently provide disability benefits, email the Workers' Compensation Board Plans Acceptance Unit at pau@wcb.ny.gov, stating that you plan to provide paid family leave to employees. If insured for disability benefits, notify your disability benefits insurance carrier of your decision. You may choose to either pay for the cost of coverage or take weekly employee payroll deductions. Once you have obtained coverage, you submit an application to the New York State Workers' Compensation Board, along with providing notice to unrepresented employees at least 90 days before collecting employee contributions, if contributions will be required. Paid family leave has been live since January 1st, 2018. As New York continues working closely with covered employers and those looking to voluntarily opt in, there are a number of resources to help you. Complete details on paid family leave are available at paidfamilyleave.ny.gov, including the Public Employers page, which has lots of resources and tools to help you. You can also access opt-in, request and waiver forms, weekly benefit and deduction calculators, as well as resources to share with your employees, like a recorded webinar and fact sheets. You can also find information on changes to paid family leave for 2019 via a link at the top of the website homepage. You and your employees can also contact the Paid Family Leave Helpline at 844-337-6303 for assistance Monday through Friday from 8:30 a.m. to 4:30 p.m. If you are not already subscribed to email updates on paid family leave, you can subscribe by clicking Get Updates on the bottom of the paidfamilyleave.ny.gov homepage. Finally, we also want to make you aware of the board's Advocate for Business. The Advocate for Business is the liaison between New York's business community and the Workers' Compensation Board, giving employers one place to contact for answers to their workers' compensation questions, as well as any questions employers may have about paid family leave as it relates to your business. You can contact Neil Gilberg, the Advocate for Business, at 518-486-3331 or neil.gilberg at wcb.ny.gov. Thank you for the opportunity to discuss New York's landmark paid family leave with you. We will now use the rest of our time to take your questions. Please keep in mind that the board is unable to provide legal advice, which includes guidance about what you should do in specific situations. If you have specific questions or concerns about a request for paid family leave, you should contact your disability and paid family leave insurance carrier, as they are the entity that makes the decision to pay or deny benefits.
Thank you, Jen. We're now going to begin the live question and answer period. As a reminder, please use the chat feature to send your questions by either hovering over the WebEx tab at the top of your screen and clicking on chat, or by using the chat box if it's open on the right-hand side of your screen. I will read your questions out loud, and Courtney from our counsel's office will be responding. You may hear some brief silences throughout the Q&As as we're reading your questions, and a brief silence between questions. So please give us a few moments to review your questions, and we will get back to you shortly. Thank you. Okay, our first question is, if the employee does not keep up with health insurance payments while on paid family leave, will the employer have the ability to terminate their health insurance benefits based on non-payment?
And so the answer is yes, but you do have to comply with certain notice requirements and things like that, and you can find all of those requirements in section 380-7.3 of the regulations. And there is a link to the regulations on our website, but the answer is yes. If the employee regularly contributes to their health insurance and they just don't pay their portion that they normally pay during paid family leave, there is a process to cancel their health insurance.
Our next question is, must employees still contribute to paid family leave in the first 26 weeks of their employment, even though they are not yet eligible to take paid family leave?
So the employer is entitled to take contributions, the deductions from the employees while they're gaining eligibility, because they're still, it's to cover the cost of having that person on their PFL policy. So the employer is entitled to take deductions even if the person has not yet reached eligibility, unless they qualify for a waiver.
Our next question is, for the 26 consecutive weeks, does this start at the time the paid family leave program is implemented?
So no, it starts at time of hire. So what the statute and the regulations talk about 26 consecutive weeks of employment with a covered employer. So it sort of depends if you're a covered employer. If you're not a covered employer, they opt in and they're in employment. It does start from date of hire, not necessarily from the date PFL was implemented. If you don't have employees in employment and you opt in, they may have to be in employment for those 26 weeks before they can take it. But generally speaking, the eligibility is the entire length of service, not from January 1st, 2018.
Our next question is, if a union bargains for this benefit, are all members required to contribute?
So employers are entitled to collect contributions for anyone that they're covering for paid family leave. The terms of the collective bargaining agreement might address it and might have other rules. Additionally, there's nothing specifically prohibiting an employer from taking contributions from some employees and not others, but there could be other areas of law that address it, like employment law or something like that, that prevents you from taking deductions for something like paid family leave from some employees but not others.
Okay, next we had someone ask if we can quickly review the details about a mother taking maternity leave.
Sure, so employees are eligible, so for 2019 we'll do, for this year, there's a maximum of 10 weeks. So an employee can take up to 10 weeks of PFL to bond with their new child. So if they have a baby or if they adopt or have a child placed with them for foster care, they have 12 months from the date of the placement or birth to bond with them. So that's both a birth or a placement, and they have 12 months. In 2019, it's up to 10 weeks. And another thing to keep in mind is that if a mother does give birth and she's eligible for example, statutory disability, and she wants to take that first, and she's eligible for both disability and PFL, she can choose to take disability first and then PFL after that, but it is subject to a combined maximum, so statutory disability and paid family leave. There's a combined maximum of 26 weeks in any 52-week period. But bonding leave can only be taken after the child is born.
Our next question, when completing Section B, Question 9, regarding calculating average weekly wages, is it required to include days employees are not paid?
So you use the last 8 weeks that the employee worked and received wages. So if there are days that they worked in those weeks, you include them in the calculation. So if, for example, somebody works 5 days a week, 1 week, 3 days a week, the next 2 days a week, so these are all the 8 weeks preceding the PFL, you're still going to use those weeks in the calculation of the average weekly wage.
Okay, our next question is, if, as an employer, we require employees to charge appropriate available accruals while out on FMLA designated leave, and the employee requests PFL for the same time frame, can the employer deny the PFL on the basis that they would earn more than they are entitled to?
Okay, so there's kind of a few things at play here, so I'm just going to kind of lay them all out, and hopefully that will give you a clearer picture. So the first thing is that the employer, unless they are a self-insured employer, the employer is not the entity that's making the decision about the request for paid family leave. So generally speaking, an employer cannot deny a request for paid family leave for any reason. It's just not their role, it's the carrier's role. The second thing is, and I mean, you seem to understand this because you're saying while on FMLA they're also taking PFL, is that PFL and FMLA for the same qualifying event can be required to be taken at the same time. Employees are not entitled to more than 100% of their wages during a period of PFL, so they're not going to get more than 100%. Right on the PFL request form, there is a section for the employer to fill out, like, is the employer receiving full wages? If the answer is yes, you know, then the carrier knows to contact the employer and get more information because the employee is not entitled to more than they receive. But it's not the employer's role to deny, it would be the carrier's role. The other thing that I want to mention is the question of whether or not you can force the use of accruals. So the paid family leave law says that you cannot force the use of accruals during a period of PFL. The FMLA may allow it, and if you're requiring them to take it at the same time, there becomes a question of, okay, well, I'm forcing them to use accruals under FMLA, but PFL says I can't. Can you do that? That depends on the federal law. The federal law, it's a question of federal law, and the board does not have jurisdiction over federal law. So for a question of whether or not you can do that, you would need to contact FMLA, and it's the Wage and Hour Division. If you just Google that, it comes up with their website and a phone number. But the board doesn't have jurisdiction over federal law, so we can't make a determination of whether or not you can force the use of accruals when you're taking PFL and FMLA together.
Okay, we have a similar question. Can you stack FMLA and PFL, parentheses, use accruals while on FMLA and then use PFL?
So generally speaking, the statute does say that unless the employer expressly permits otherwise, FMLA and PFL for the same qualifying event, so for example, bonding leave, they're going to be taken at the same time. So the employer can require FMLA and PFL for the same reason if there's FMLA and PFL available to take them at the same time. But if an employer allows, they can allow stacking of leave if they want to, but they don't have to.
Okay, someone asked for us to repeat a section of law regarding non-payment.
Yeah, so if we're talking about the non-payment of health insurance premiums, it's section 380-7.3. That's 380-7.3. And again, there's a link to that on the PFL website, so you can get to all of the regulations. So not just that, but it is 380-7.3, which talks about health insurance during leave.
Our next question is regarding carrier rates.
So it looks like the question is just kind of a little bit, you know, how the carrier rates work and things like that. So the rate set by the Department of Financial Services each year based on the cost of coverage. So across New York State, all the people that are covered for paid family leave. And for 2019, it's 0.153% of the gross wages for a pay period to that annual cap of about $107. And no single employee is going to pay more than that $107. So that's the maximum that any single employee is going to pay for an employer to be covered on their policy. If the employee makes less than the state average weekly wage, then they may have a lesser premium amount. So somebody who makes $20,000 a year is going to have a lower premium amount, so it'll be less than that $107 versus somebody who makes $100,000 a year. So it is going to be based on their actual wages. So I do see, just kind of scrolling through the questions, there are a lot of very, very detailed and very specific scenarios that people are asking about. The board can't give legal advice, so we're not going to be able to give you specific guidance about what you should do. You can also call the helpline, and you know that's at 844-337-6303. It's a little bit hard to do these kind of very long, detailed questions in this format anyway, because I think it would be very difficult for other people to follow along and get anything out of it. So if you wanted to call the helpline, but also just keep in mind that the board is unable to give legal advice.
Next question, is the $107 an annual max?
So the answer is yes. For one single employee who works for a covered employer, they're not going to pay any more than that $107. I think it's 97 cents. That is the max for that employer. So the employers cannot take any more than that, and that will cover the cost. So the premium rate is set so that the deductions match the premium cost. So an employer won't pay any more than that $170 for each person that they have to cover for paid family leave.
Okay, the next question. Will the amount an employee contributes to PFL fluctuate over time based on the immediately preceding 8-week period of work, since they may work some days in that period but not others?
So I think that it's kind of smushing together two things. So I'm just going to kind of talk about both things that I think you're asking about. So the amount of the employee's contribution, so their deduction, may fluctuate over time because it is a percentage of their wages for a pay period. So, you know, for example, if they switch from full-time to part-time, that could significantly impact how much money they contribute because they're working less, and that's reflected in their wages. So that's calculated separately, but it isn't calculated using the last 8 weeks. It's calculated just using the amount of money that they're paid. So that's how you calculate the deduction. The second piece that I think you're kind of asking about here is average weekly wage. So average weekly wage uses the last 8 weeks before PFL. So correct, it's possible that if you look at an 8-week period 6 months ago versus an 8-week period now, the amounts could be different because that's how the regulations define average weekly wages using the last 8 weeks. So it is possible that over time those numbers change. So we want, you know, the theory is to get the most accurate picture of an employee's wages, average weekly wage of what they're working right now. So that's why you look at the last 8 weeks. So it is possible over time that it fluctuates, but those are kind of two separate things that I think you're asking about there.
All right, it looks like that's all the questions that were submitted using chat. Thank you, Courtney and Jen, and thank you to everyone on the line for joining us today. Remember, if you have any questions that we didn't get to or resources, there's resources available on the Paid Family Leave website, and the helpline is also available for additional information and assistance. If you haven't already, please sign up to receive Paid Family Leave news straight to your inbox. To sign up, visit the Paid Family Leave website, scroll down to the bottom of the homepage, and click the Get Updates button. We also distribute great information on PFL via our social media channels, so please follow the Workers' Compensation Board on Facebook, Twitter, and Instagram. We thank you again for your interest in paid family leave, and have a great afternoon.